your weekly program بالأحضان, a show with an accent for those without one. I mean, two things we need to talk about before we get into our main issue here, which is the Saudi. Everybody say he's a journalist. He wasn't really a journalist. He was just, one of the loyal family advisor. He just kind of fell out of favor with the Prince bin Salman, whatever this guy is, that he coming like he now starts acting like Gaddafi. So Jamal Khashoggi, as you all know by now, getting into the Saudi's consulate in Turkey, and people saying abducted, killed, dismembered and shipped back, and a lot of conflict. And you have Trump saying, sad, I'm following, but I cannot stop arming the Saudis because we're going to get hurt because jobs and all of that. He's comparing losing a few jobs here in the United States to this killing and the mass murdering of a civilian that is a dissident of the royal family. So it's really it's a sad situation. It's a tragedy. The head of states now are acting like mafia thugs, and it's all over the world now. In Egypt, Al-Sisi is acting like a thug. Man, nobody can. And I think the Arab dictators now emboldened in a time for Trump. Everybody knows they can get away with it. And I think with the blessing of the Israelis now, I can imagine the Israelis lobbying in behalf of the Saudis here in Washington. So it'll be interesting to see what is the fate and what is going to end up with this Saudis that he's been kidnapped and killed because of his opinion or his disagreement with the policy of bin Salman. Anyway, the second thing is we're all over now the Kavanaugh's hearing, and now it's confirmation. Now he is in. So what is the legal ramification of having somebody was accused of sexual assault? He's been appointed by somebody who was accused of sexual assault. It's really bizarre. But the real stuff is when all the camera now is gone and the dust is settled, what is the legal ramification? Why was it a circus? Why took that long? What is the process, the qualification of a judge to get into the Supreme Court? We have here a retired lawyer and a former prosecutor. He was following this, Peter Thompson. Welcome to Balahdan, Peter. And I think the political circus and the political hopefully now settled down. But let's, from a legal perspective, for those 2 weeks of hearing and everybody showcasing his ability, whatever, what was the issue discussed in that hearing that is really there were people after, beside he likes beer, beside he is unhinged, beside he's screaming at people, that the media paid more attention to those non-issues?
Well, first of all, the judge should be qualified in terms of academically qualified. That is, have the competence to properly decide cases. That was a lot of what was discussed in the first go-around in the case. Mm-hmm. And normally judges aren't disqualified because, they may have views that are dissatisfactory to one party or another, as long as their analysis and their academics are sound. Once in a while you will have a judge, Judge Bork got bounced for having extreme views. And there were some attempts in the first hearings to try and show that Kavanaugh had extreme views about primarily things like the scope of executive privilege. Lots of what comes up with the Supreme Court, which is very important and we'll get to in a little bit, is that they have to decide when they're going to step into a case and when they're not going to step into a case. Because the judicial branch has the responsibility to interpret. And when they interpret, sometimes they will slap down Congress, sometimes they will show the outer limits of executive power and push back on that. And so to keep the proper balance, they have to know when to do that and when not to do that. So that's why they were talking to him about this unitary executive privilege and some of those things. That came up back during the George W. Bush administration, came up the biggest time during the torture issues.
Yeah.
Because there was a lawyer in the Office of Legal Counsel in the Department of Justice, John Yoo, who wrote a memorandum that basically said torture was legal in some circumstances.
Didn't also Judge Kavanaugh has something to do? Wasn't he has a view about torture? Was he involved in that case during the Bush? Wasn't he an advisor of Bush?
I think he was involved in the Bush administration. I don't think it was really developed at the hearings how much he got involved, and I think he distanced himself from those things. But the reason I was saying that is John Yoo came up with the theory that even if torture was illegal, wrong, he said in a time of war, the commander-in-chief, if the commander-in-chief has directed people to use these coercive interrogations, they can't be prosecuted because the power of the executive is so all-encompassing and so strong. And so what's really important about that is that is a view of the executive that is so expansive that it crowds out congressional oversight and judicial oversight.
Well, nobody's above the law.
Exactly, and that sort of thing would be specifically, there could be circumstances where you have an emergency where the executive can be above the law. And that's exactly the opposite of the Nixon case in the Supreme Court when, Supreme Court says no one's above the law, not even the president. And that was an example of the courts pushing back. So when the court does its proper function like that, it makes the court, it gives the court integrity. It makes the court believable. It makes the court function in the way it should in our democratic system.
Yeah, and this is an interesting point because, when you look at the American people, the population, I think the Congress is people don't trust politicians anymore.
Very.
They don't trust our executive branch. So what's left is the judicial.
What's left, and the whole judicial branch, and we have some wonderful federal judges in the state of Minnesota. The whole federal bench generally had at least a wonderful reputation. After Bush versus Gore, that went downhill a little bit because everyone saw, how do you vote in a case where 5 Republicans vote for Bush and 4 Democrats vote for Gore? People start thinking, are these guys politicians?
Yeah.
And so that is one of the big things that came out. So the first thing I've identified is competence. And, there probably wasn't going to be much controversy about that, and he was going to sail through probably 52 to 48 or whatever it was on party grounds. And then the Dr. Ford allegations came up, and then his pushback on that and denials, and then his unhinged, as you've called it, and then his comments about political conspiracies and circus and those
Clinton,
sort of things.
whatever.
So now that brings up 3 other things besides the competence that should be considered to determine if this person has the character, fitness, and capability to be a federal judge, any federal judge.
Yeah.
But, it's just sort of on steroids when we talk about the Supreme Court.
Yeah.
So, in terms of the sexual assault, as harmful as that is, what really would add to the integrity of the court, it certainly would be very harmful. But
would it disqualify him? Something happens 37.
What would disqualify him, in my opinion, would be if you believe Dr. Ford, okay, and he says, I didn't do it. If in that consideration, you come down with Dr. Ford, that means he was under oath in front of the Judicial Committee of the Senate.
Yeah.
If you believe Dr. Ford, then you would believe that he had made a false material statement under oath. It's material because it would affect, you know, the qualifications for a judge. We can't have a judge be sexual assault artists, right? So the commission of a crime that is perjury in front of the committee would be a disqualification as a judge. Now what happened, the way the committee, and I think a lot of the public got completely misdirected about all this, is they then turned it into something talking about the presumption of innocence and the proof, and they had the FBI investigation, and correct me if this wasn't your understanding, but the way it was being talked about, particularly by Senator Collins, was, well, we have to give Kavanaugh the presumption of innocence, and we can't further corroborate exactly what happened in that room, and therefore we can't hold it against him. That is completely off. What was to be considered by the Senate was whether or not you would, so to speak, approve this person's application for a job. In other words, the burden is on the applicant. This is a civil proceeding, and the burden would have to, at least by a preponderance of the evidence, maybe by clear and convincing evidence, convince a majority of the people on that committee that that person was fit. The burden is not upon.
Well, if this is the case and this is the procedure, why did not happen? I mean, you have a committee that run by the Republicans, and then so what is the role of the Democrats that they understand the law and they create the laws?
There was so much confusion, and people didn't have a clear view about what these issues were. I was very upset because, like, Collins came on and says, well, I've got to think about the presumption of innocence, and therefore, you know, I have to vote for this person. Now, whether you believe she's more interested in getting reelected or not, but that wasn't the issue, because he was not under investigation or trial for a crime. That's where the presumption of innocence comes up, and that's why the burden of proof is always on the prosecution, and they have to get corroboration of the victim. This is not a criminal case.
He's going to the Supreme Court. Dr. Ford is not.
Exactly. So he's got the burden to prove that he is proper. So if you believe her and you don't believe that he has an adequate excuse, and Amy Klobuchar gave him a perfect opportunity for an excuse, because she said, could you have blacked out? Because that would have looked like, you know, he was a teenager, he blacked out, so that's why he can't remember. And he was very snotty to her and says, have you? And so, but he didn't black out. He knows, you know, who the person is. He was at the party, she was at the party, and so he's just saying, and they should have pushed on this, is she then lying? And so that's what it really came down to. So it isn't.
She became the one that is accused.
Exactly.
She was not running.
Exactly.
I just did
See,
not.
you get it now, and they didn't get it. And the way they got it hurt all sorts of women who have been disregarded down through the years, because it doesn't matter. We're not trying to convict him of a crime for something that happened 36 years ago.
We want to just make sure he's qualified, that's all.
Exactly. And if he committed sexual assault, they probably wouldn't qualify him. And if he lies under oath, that's an automatic disqualification. That would have been committing a federal crime in that Judicial Committee room.
You've seen the old 2 weeks, whatever, you're following them. Should he be qualified to go to the Supreme Court? From your own opinion. What's your background?
Okay, I've got two other things to talk about. We've mentioned them, but in addition to a false statement, when he indicated that this was a conspiracy by the Clintons to pull a circus and to try and get him, I think that showed that this is really a political animal. And as I indicated before, the Supreme Court is supposed to be apolitical. And so I think the whole problem with the population believing that if the Congress gets it wrong and the executive gets it wrong, at least our Supreme Court is fair and just and impartial, and they'll get it right. We're losing ground on that. And if the people stop believing and having confidence in the court, they're going to start losing confidence in the whole government. And that's a real tragedy. And so there was two things that happened. Number one, that was a very political response
And he
that he
in the
gave.
get-go said, I'm impartial, I'm not political.
Right.
And then now brought Clinton, and he brought conspiracy, and he brought politics into this.
I've picked hundreds of juries. I've tried 200 felony cases, jury cases to completion. Every juror you talk to says, almost every juror, some of them are honest, and say, no, you're representing a drug dealer and I can't be, but almost every one of them says, I can be impartial. Everyone thinks they're impartial.
Yeah.
So you need to look beyond that.
I see.
And then when someone says something like that, you realize that the impartiality is not there.
Is it really, when we say the court, and especially in the Supreme Court, which is the highest in the land here, and every judge has to be impartial and all of it, are we realistic? What are we talking about? And the records tell us otherwise. Otherwise, Gore would have been the president, not Bush, who will not be invading Afghanistan and all of that. So what we're trying to say here, if we know in fact, but this is really a fallacy that you have impartiality in
It's not a complete fallacy, because we have several instances where someone got appointed to the Supreme Court. They had a certain political bent, probably not a bias, and they grew as justices, and you can tell it through their opinions.
I see.
Because justices are in a wonderful position. They look at precedent, but they can change precedent. They can overrule cases. When the Supreme Court says what the law is, lower courts have to follow it. The Supreme Court, interpreting the Constitution, can change the law. And so as you get in that kind of position, Harry Blackmun was a great example. He got appointed from the Eighth Circuit Court of Appeals. He worked for Dorsey here in Minneapolis as a lawyer. And then he was an Eighth Circuit judge, and a very brilliant judge, and quite conservative. When I was a prosecutor and I'd have a case in front of him, I felt pretty confident. When I was a defense attorney and had a case in front of him, I thought, uh-oh.
Really?
Yeah, I'm not going to have a very good chance. He got on the bench and he did some amazing things in terms of the individual rights.
But
he did just some beautiful things, and probably the greatest example of all of how becoming a justice, there was a man who was the Attorney General of the state of California, and he went in front of Congress and he talked Congress into making a nationwide ban against Japanese Americans, and they locked up 120,000 of them.
Yeah.
Okay? Guess who that man was?
Who?
Earl Warren, who became Chief Justice of the U.S. Supreme Court, wrote the Miranda case, and did a world of good for individual liberties. He grew out of that. He apologized in his memoirs for having done that. But that's the same man. And so sometimes...
So should we take our chances on this aberration? So there must be a procedure or some kind of oversight to guarantee those judges are going to be impartial. And he should be disqualified, the people that show the tendency to become impartial. Like, I'm just for an light bar. This guy loves beer, and he keeps saying, I love beer about 20 times. Let's say, for the sake of argument, that we're going to bring prohibition back. Would he be on the court? And it's going to go to the Supreme Court.
He would.
He loves beer.
He would, under the federal law, if the litigants challenged him, he should recuse himself.
We'll have 9 judges.
Yeah, and then there'd only be 8 that could decide that case, because if the facts were as you said they were, and he would find that he was biased in that regard, he should recuse himself.
I know they've been screaming at us, but we're going to extend a few minutes here. This is a lifetime appointment, right?
Right.
Is this still relevant? Should we revisit this and see if maybe it outlived its usefulness?
I grew up with two ideas, when I was in federal court, which I was in quite a bit. And one was a lifetime appointment is good because you are no longer subject to outside influences because you have to run in an election. Let's say Collins probably voted the wrong way just to win the election. I don't know, but for example. So if she had a lifetime appointment, she could just call it the way she did. The other problem with lifetime appointments is, maybe there should be some term limits. The other problem people are talking about now is maybe we should have 10 judges or 11 judges.
Why is that?
I suppose
How is it different than 9?
Because
50-50, I guess?
Well, the problem is now, they're saying, is that if Kavanaugh is the 5th vote, like Kennedy used to be most of the time, and the court's getting more polarized. I mean, Ginsburg said some pretty, mean things about our president, that maybe Kavanaugh or one of those other 5 will basically be deciding the law in the future. And so to break that up, if you had 10, to win a case, it would at least have to be 6-4.
I see.
Not one person carrying the cudgel.
I see.
Now, to those things, I think those probably would be a mistake because we've been operating this way for a long time. The operations go pretty well. But it's good to talk about those kind of things. The other thing is, people get pretty old. I mean, I'm not near
But the
sharp
average is
as I
about
used to be.
20 years, 25 years. It's an average appointments.
Yeah, well,
that's a lot of
they're
years.
getting smart now. They're both sides are trying to appoint young people, so they'll have
exactly.
some
And
influence
then
for a long
Kavanaugh
time.
is 50 something.
Yeah.
This guy maybe 30 years.
Yeah, it's possible.
Well, Peter Thompson, a retired lawyer, a former prosecutor, is just enlightening us about the legal ramification of hiring a Supreme Court judge and what happened during the confirmation of Judge Kavanaugh and the implications.